Right, good afternoon everyone, and welcome to this latest SCL webinar, where today we are discussing the Privacy Shield is dead, long live what? I'm David Chaplin, Editor of Computers and Law, and I'm joined today by an expert panel you can see on your screen to discuss the implications of last week's decision in, let's call it Schrems 2, which saw the dismantling of the Privacy Shield mechanism for transfers of personal data, international transfers of personal data. With us to discuss this today are Renzo Marchini, partner in the Privacy and Security Information Group at Fieldfisher. Florian Tannen, a partner at Bateman McKenzie in their Munich or Berlin office. Sorry, I might have got
It's
that wrong.
the Munich one.
Munich office, in the Munich office, yes, thank you. Katalina Bateman, Counsel in the IP, Tech and Data Group at Reed Smith, LLP. And Janet Lane, who is a legal privacy counsel at Refinitiv, in-house counsel there at Refinitiv. Renzo will start the discussion today by summarising the judgment and the conclusions of the court, and we will then move on to a panel discussion between the panel to hear about their immediate thoughts on some of the questions facing us now, before we'll move on to questions and answers from the audience. Before I hand over to Renzo, though, just a few more housekeeping points. Please do send in your questions, as I said, and comments via the Q&A panel. We do have a large number of attendees today, so we'll do our best to answer as many as possible, but if we don't get round to you, apologies, we'll just run out of time. I must also point out that the opinions shared during this webinar are the speaker's own and do not represent the previous or current employers. And finally, this event is free to air, as you know, but if you find it useful, please do think about rewarding us with buying us a coffee and to help support our student schemes at buymeacoffee.com/SCL. So with that said, I will just hand over to Renzo, who's going to give you a quick run through the facts and the conclusions of the case. Over to you, Renzo.
Thank you. So hello everyone. So the quickest facts and summary of the case then, because most people are familiar with the history of it. It's all to do with Facebook Ireland, of course, sending data to Facebook Inc., Max Schrems not liking that very much, Max Schrems bringing a case back in originally 2013, which hit the CJEU in 2015 when it killed Safe Harbor. Out of those ashes came Privacy Shield and a second case which challenged the use of the standard contractual clauses that Facebook Ireland said it was using to legitimize transfers to Facebook Inc. And the reason the case is, of course, in Ireland is because, to use the language of GDPR, the lead authority for Facebook, whose main establishment in Europe is Ireland, is the DPC. So to my mind, Schrems 1 and Schrems 2 seem analogous to a blockbuster film and its sequel. In the first case or film, there was a central plot, the tension between US surveillance rules and EU fundamental rights. And there was, of course, the death of a major protagonist in the form of Safe Harbor. In the second case or sequel, that central plot is revisited. There's the death of another protagonist in the form of Privacy Shield, but crucially, another character, standard contractual clauses, survives but needs to develop and grow into a more prominent figure. So what did the court actually decide? Well, I'll take this in two pieces. First of all, on standard contractual clauses, the court did follow the opinion of the Advocate General, which was in December last year, and concluded that they did remain a valid mechanism for exporting data from Europe to outside the EU. Crucially, however, the court ruled that there will be circumstances where the SECs alone might not be sufficient to satisfy the high standards of EU law. The example of the circumstances cited by the court were when the laws of a third country allow its public authorities to interfere with EU fundamental rights, in short, local surveillance requirements. And the court then set out what organizations needed to do in practice to rely on the SECs. And it's a two-stage process. First of all, the controller, the exporter, must verify on a case-by-case basis, in the context of a particular transfer, the laws of the third country to ensure that the recipient can comply with the SCCs. If that test, that assessment passes, the SCCs can be signed and the transfer take place without anything in addition. However, if there is a problem with the laws of that third country, and again I emphasize in the context of a particular case on a case-by-case assessment, then the parties need to put in place so-called supplementary measures or additional safeguards. The three different expressions that are used in the judgment, but to me they certainly mean all the same thing. If it's possible to implement these additional safeguards, the SCCs can be signed and the transfer can take place. If it's not possible, the SCC shouldn't be signed and the transfer should not take place. In addition, and also importantly, the court did remind everyone, data exporters, data importers, of their existing obligations under the SCCs. The processor must notify the controller if it's unable to comply with the SCCs. The controller must suspend or terminate the transfer if the recipient is unable to comply with the SCCs, and any data that's already been transferred must be returned or destroyed. Finally, the CJEU provides scope for supervisory authorities to intervene and police the transfer in the event of non-compliance. So what are the implications? And I take four different key aspects from the judgment. First of all, the CJEU seems to be giving real effect to the SCCs. There's been a long-held school of thought that some organizations have simply signed them as a box-ticking exercise and then put the document in a bottom drawer, filed it away, while actually doing anything in practice. Schrems 2 appears to counter that approach to the extent it existed, and a lot of organizations I know did take their commitments seriously, and does invite companies to live up to their responsibilities and invite DPAs to regulate that topic more closely. That said, and we were discussing in preparation before we started, we know of little significant enforcement from DPAs in relation to data transfers. We know little or no examples, I know of no examples of a data exporter ever suing a data importer for breaching the commitments, and leaving aside Max Schrems and Facebook's, little by way of public complaints, although I know Florian knows quite a few in Germany, and maybe you'll mention those later. Secondly, the concept of the verification process will be new to many controllers. Unsurprisingly, controllers will be confused and might find it onerous to find that they now have to verify the surveillance laws of a third country. However, pending guidance from regulators, it may well be that there are three elements to this process. First of all, as an exporting controller, you might ask whether the organization receiving the data is actually subject to the surveillance laws. Taking the US as an example, of course, that's what's been heavily discussed recently, and FISA, Max Schrems himself and NYOB make a big point about not all US companies are subject to FISA 702. He's a little bit disingenuous in that, but he does make that point. Secondly, consider the types of processing activities undertaken. There's a big difference between social media, telecommunications interactions, including location data, and maybe vanilla HR processing or vanilla payroll data. That will factor into the risk assessment, I think. Thirdly, and the court does ask controllers to do this, you have to look at Article 45.2 in theory. Article 45.2 sets out the factors that the European Commission considers when determining adequacy of third countries. And it sets out various criteria which now need to be a mini assessment of the adequacy or the risk of a particular transfer by controllers. What might actually emerge out of this, and as I say, it's crying out for regulatory guidance, and I hope we'll get some, what might emerge is a standard accountability document, call it a lawful transfer assessment, to sit alongside legitimate interest assessments or DPIAs that you actually document as part of putting in place data transfer mechanisms. In practice, European customers will inevitably lean upon foreign US service providers in helping them undertake that assessment. The third bullet point on the slide and implication that's taken from this judgment are the additional safeguards, and that's the killer difficult issue. What are these additional safeguards that could be put in place? And I'm sure this will come up in discussion, but just to set it all off, I see three different buckets. I see technical safeguards. Might you be able to encrypt the data in Europe so that if it did end up in the dreaded NSA's hands, then they can't actually do anything with it, notwithstanding they've probably got the best decryption technologies in the world. You might be able to encrypt it strongly enough so it's meaningless. That won't make sense in every situation, in fact, maybe in many situations, but technical safeguards perhaps. Secondly, contractual. Can you get something in addition to the standard contractual clauses from your service provider, similar to what might appear in BCRs, for example, in order to help police against possible law enforcement encroachment upon your data and get some more contractual promises. Thirdly, related to that, some policy rollout in the recipient company, dealing again with how law enforcement requests would be dealt with. Lastly, and the next takeaway on SCCs is that there's inevitably going to be quite a bit of commercial friction and uncertainty arising from the judgment, and pending comments from regulators, SCCs will be seen in one form or other, but inevitably there's going to be discussions and negotiations in relation to it. I'm going to use up slightly more than my 10 minutes. I'll be very quick on Privacy Shield, which perhaps not quite as practically of interest now going forward, given that it's dead. So it died because it wasn't essentially equivalent, the key phrase, and the court went through an adequacy assessment, again, similar to what's set out in Article 45.2, and it died because Privacy Shield did not provide sufficient protection for European data. In particular, EU individuals, the court found, or the Irish court also found in its reference, didn't have actionable rights before the courts against US authorities that might be used in FISA. The mass surveillance was not limited to what was strictly necessary in a democratic society, to use an expression that we all know. The ombudsperson concern that was supposed to fill, concept that was supposed to fill some of the concerns coming out of safe harbor, wasn't properly independent from the executive, did not give proper redress to individuals. So the bottom line is, on Privacy Shield, it can no longer be relied upon. Having said that, and again, we just talked about it before starting, the US Department of Commerce still says it is carrying on policing it. People have certified to it. You're under sanction of the FTC if you don't comply with your principles as a member. Indeed, the ICO has said UK companies that have been transferring data to members of Privacy Shield should continue to do so for the time being, whilst everyone assesses what happens next. But the reality is that anyone that's on Privacy Shield is already beginning to think about putting in place standard contractual clauses, rolling them out in some form or other with a click wrap or a notification, or call for it if you want it. Some difficult issues arise when a lot of service providers might position themselves as processors in the past, hide behind Privacy Shield and not worry about their own use of the data for improving products for machine learning, and fudging the issue that they might cross the divide between controller and processor in their contractual documentation, but now might have to make some more difficult decisions in relation to which flavor of standard contractual clauses to put in place, C2C or C2P. And David, so that's my introduction, and I hope that was helpful.
Excellent. Thanks very much, Renzo. Yeah, very useful putting things into context and give us a quick run through of what some of the things that people can start to think about doing now. We're going to kick off the discussion with just a few words from everybody. Was the decision the right one in law, and is it the right one in practice? So start with you, Janet.
So I think, is it the right one in law and practice? It's hard to come against a judgment that defends EU data subject rights. I think at heart that's what it did. It was making sure that wherever our data goes as EU citizens, that we have rights that we can enforce against it. It does, however, just raise some really interesting practical questions, and I think this is where we are all at the moment. What does that mean in practice when global business is a fact? We we're in a situation where a lot of companies are wanting to ensure they do business well. They want to increase the economics, and they want to do so in a compliant way. So understanding how we do that after a judgment like this, I think, is where the interest comes.
Katalina, some thoughts?
I mean, it's a decision that comes from the highest court of the European Union, so it's hard to shy away from that. And perhaps unsurprisingly, it largely follows what came out of the Advocate General's decision, a non-binding opinion on the case. I guess what was perhaps less expected was this ruling on the invalidation of Privacy Shield. Set aside that it happened with Safe Harbour, so this is Mark II. But I think that's what has maybe provided so much content for a lively debate, let's say, in these last few days, and not just on the legal and compliance side, in terms of the implications of the decision, but also around issues on policy and national security, and international political relations, which I don't think is going to be the focus, perhaps, of today's discussion.
And Florian, from a German point of view, European point of view.
Yeah, I agree with what's been said already. What is still surprising me, I agree that it was a little bit surprising that they really gone through and struck down a Privacy Shield entirely, following what the Advocate General said in December. But what still strikes me is that the European Court of Justice, again, didn't really consider or cater for some kind of grace period to react to it. If you look in the procedural law, what the ECJ could do, they could indeed provide for a grace period, but they didn't do that. And even more, they had this very bold statement, I think it's very much to the end of the judgment itself, where they say, coming from our judgment, there is no legal vacuum, which I find a little bit ridiculous, to be honest. And then they refer us to the derogations in Article 49, say, hey guys, Privacy Shield is gone, SCCs might be a little bit risky to use now, go to the derogations, which is, yeah, okay, it's legally correct, but it's practically not helpful. So I feel a little bit like dumping two people in a desert, one shooting right away and the other one I hand over half a liter of water and then leave him there. That's a little bit how I feel, I have felt, at least on Thursday and Friday.
Right, and Renzo, anything to add to what you said earlier?
Well, I agree. I mean, it's hard, just sort of joking earlier, is a decision right or wrong? Who knows? It is a decision. It's hard to reconcile the two parts of the judgment. Why couldn't Privacy Shield survive? You can use Privacy Shield as long as you put additional safeguards in place. If there was a question mark over it, and that wasn't said. But it's good news that standard contractual clauses remain. Would have been absolutely dreadful if they'd both been struck down. And again, notwithstanding what Schrems is saying at the moment, it does seem to be capable of being used with US recipients, and why ought it not to? The court did not say, and could have said, you can never use these in the US, but they didn't say that. Is it the right judgment? I don't know, but it's good to see the European Commission fast out of the blocks, and maybe there'll be a third attempt at doing something for EU-US transfers.
So moving on, I mean, obviously, yeah, we can forget the Privacy Shield now, but what impact will this have on your clients now? I mean, we don't need to name specific ones, but what sort of questions are you getting asked now about what people should be doing? Perhaps who wants to come in on that one?
I mean, I think we're all going to concur on the fact that the primary recommendation is going to be don't panic, and don't make any rash decisions in this immediate aftermath of the decision. I think those that were relying on Privacy Shield clearly have to revisit what alternative transfer mechanism they can rely on. And for a number of organisations, that is going to be putting standard contractual clauses in place. Of course, you can go through the motions of, will any of the derogations under Article 49 apply? how often have we been able to find a non-restrictive circumstance where they did? Are BCRs going to be appropriate for your organization? Given how long they take to put in place, and how they're not necessarily appropriate for organizations, they're not going to be something that you're going to jump into. Is individuals' consent feasible? I think for all of the reasons that consent is never the first option that you go to, given the administrative burden, the fact that it can be withdrawn at any time, perhaps not the most desirable of options as well. And perhaps you also consider whether some data transfers can be avoided if you can switch to an EU storage site. But as I mentioned, I think for a large majority of organizations, it's going to be considering whether SECs are viable. And that comes with a big however, given the additional safeguards and this assessment. I think we have to come up with a communal term in terms of whether they're going to transfer assessment, transfer impact assessment. Let's definitely not call it a data protection impact assessment, because it's quite separate.
No, I agree, and I'm going to throw another term in. It would be adequacy light assessment or something like it. The questions that mainly clients are raising right now with me is obviously whether the German authorities are really doing what they say they are doing. In particular, the Berlin one. That, David, I was very glad that you asked me where I'm coming from, because I like to say I'm Bavarian and not German, and that I don't really be in the same group as the Berlin DPA right now. They took the easy way out. They actually said, hey, it's going to be easy. Just relocate all your data to Europe. Use European service providers. Stop transferring data abroad entirely. And I think the European Data Protection Board said, we take note of the statement of the ECJ saying that we should enforce and stop data transfers. The Berlin DPA said we embrace the statement of the ECJ and looking forward to actually doing it. As I said in our preparation, I'm glad it's only Berlin. The other German authorities are either rather calm and don't say anything, or more or less just provide quotes from the judgment right now. So it's not very much is going on. But the Berlin's, that's a really concerning thing, and it's most of the questions I get right now.
I mean, that's interesting you say about transferring all the data. I mean, as a small organization myself, you look on Dropbox, I said, oh, if you've got Dropbox business, you can put it all in Germany, but you've got to have at least 15 people in your team to be able for you to take that advantage of that. So, I mean, I know, Janet, we had some comments about SMEs. Have you got any thoughts about how SMEs might cope with this decision?
I think we were talking about what kinds of industries could be impacted. And I think the answers all are going to be impacted. Anybody transfers data nowadays, whether you're using it for cloud or hosting. So everyone will be looking at this judgment. I find it interesting that SMEs, there's so many of them. So I think there's 90%, 99% of businesses in the EU are small. And what are additional measures, safeguards, is a key question. So it's placing a burden that we don't yet know. What's that resource? What do we all have to do? And how scalable is that for the smaller businesses that might not have the resource?
Yes, I mean, it strikes me as somebody at that end that it's quite a burden if we're going to have to try and identify what's happening in the US. And what about the US perspective? Has anybody had any conversations with their colleagues in the US about how they've viewed the decision and what they're going to do about it?
I had some chats with my colleagues over there, in particular Brian Hendrisbauer, he was the guy who negotiated Safe Harbor back then. He was with the FTC back then. He was crushed actually by that judgment, because it was another step at his heart, with his privacy shield being gone now. But he said what's going to be in particular interesting is, given the upcoming election and the current US administration, how the US will take another try to get something in place. Obviously, I think the EU Commission was quite clear that they want to give it another try in the statement on Thursday or Friday. I'm not entirely sure which day it was. But it's going to be interesting whether the US administration is going doing this on the short-term basis, given what's going on over there right now. And that was the main concern that my US colleagues had, whether this is something that's going on swiftly right now.
Yeah, of course, we've seen the statement from Microsoft already, haven't we? I'm sure everyone on the webinar knows about it, but they came out, Judy Brill, the ex-FTC, came out and said, Microsoft is fine. We rely on standard contractual clauses. The court sanctioned SCCs. Carry on sending data into Azure. So that's one US view, which I think a lot of people will share. I sort of disagree with a couple of sort of comments here, in that in relation to SMEs. Now, David, you're in this world. A lot of SMEs won't even have heard of Schrems.
I know.
They're using US providers. They will just carry on using US providers until the Berlin DPA comes along and starts kicking up a big fuss, But a lot of them just don't have privacy functions. Might have one in-house lawyer who might be a generalist, and will be under pressure to sanction the deal that the business want to do because it makes sense to use this provider in Silicon Valley. So there's going to be a lot of that. What I've had already a couple of times from some clients, on the server side, processor side in the US is, how can we make our customers in Europe more comfortable? So there will be just like processors help their controller clients in preparing DPIAs, there will be processors helping their controller customers prepare whatever acronym we want to give to the data transfer assessment, or whatever. So that's going to be part of it. And there'll be FAQs, there'll be, white papers and things like that, I'm sure, from the provider side in the US. But more geopolitically, of course, and there's a point we haven't discussed yet, the court, and this was made very clear in the evidence that was given on behalf of the US government and others in the Irish case, the powers that the US authority have are very, no different than the powers that European authorities have. It's just that the CJEU cannot go there in relation to European spy agencies' access to data of citizens. Is just simply outside of scope of the European Union's competencies.
But at least, Renzo, I think that's a great point, because we might use that argument for our risk assessment. If it's okay to transfer data within Europe with similar regimes when it comes to surveillance laws, why shouldn't it be a problem to go somewhere else abroad?
Yeah, interesting. That's a good point, Florian. Yeah, absolutely. So you compare, I don't know which one. Do you want to put your hand up for Germany being the most intrusive, or
we can.
Let's freak it out. We'll have to put hand up for the UK.
It sounds like we might have to get a league table on the website somewhere. Exactly. Who's the most intrusive? And so, I think it might be worth actually broadening out. We've got quite a few questions coming through now. And I think it might be worth broadening out the discussion into some of these questions. We were talking about US companies and whether they're using the privacy shield. Somebody has said here, and I don't know whether they're right, Apple have always used, as I understand it, Apple have always used model contractual clauses rather than privacy shield. And is anyone aware of that and the adequacy of their contracts, that they've never actually gone for the privacy shield?
I'm not aware of it. And to be honest, I've seen it sound so ignorant from a couple hundred people. I didn't know that Apple, dealt with enterprise data or had any enterprise services, but maybe one of the other panelists does. As a consumer-facing entity, it is someone actually, if it had no establishment in the EU, that could rely on derogations as a consumer-facing entity, because you want to contract with a US entity, you have to send data to me, outside of EU. But whether they've got, I'm sure they must have there for some enterprise business lines that I don't know of, where I guess they use model clauses.
I don't know positive as well, but I agree with everything you said, Renzo. But I have no insights as well.
I think one interesting thing here is that our discussion has largely been focused so far on transfers to the US, but obviously this decision is much more wide-reaching than that, and it applies to any third country. Yeah. So when we're considering this transfer assessment and looking to the laws of the third country to which data will be imported, and whether it will afford adequate protections for individuals located in the EU. We also have to consider not just US national security laws, but there are plenty of transfers to lots of other countries in India, China, Philippines, Russia. The idea of carrying out the assessment of all of those different national laws, on the face of it, it sounds quite onerous and not an enviable task.
Yeah, yeah. But I mean, you're absolutely right, Katalina. But clearly, most tech service providers, more of them are based in the US than otherwise. But you're right. Anyone that's got a call center in Singapore, Philadelphia, India, will have issues in relation to using those sort of service providers there. And likewise China, I guess, and assessing those laws will be fun because they're not published, whilst at least the American ones are.
Moving on, somebody has mentioned the word encryption and come up with the question: can we all agree that encrypted personal data is still personal data and more akin to pseudonymized personal data within the scope of GDPR than anonymized personal data out with the scope of the GDPR? Can people rely on encryption and say, well, it's all encrypted, it's not personal data, so it's fine?
I think it's like Renzo said, encryption is a technical safeguard and a security mechanism. In most cases, we had one case where we successfully argued before a German DPA that the type of encryption and the way of organization of the encryption, encrypted data, encryption key led to an anonymization from the DPA's perspective. But I think that's very, very rare cases. So in general, I would agree with that statement. Encrypted data is per se still personal data.
Yeah, I mean, I think that's a debate that's been long had and pretty clear. So the point I was making earlier, but Florian repeated it, and just to reiterate, it might be a technical measure which, although it's still personal data, it allows you to assess there's no risk in a particular situation, or the risk is gone. It is an appropriate measure to allow you to continue, because although it's personal data, not in the hands of the NSA. Because they can't decrypt. Now, but you need to bear in mind, that gets you so far. The NSA would have the best decryption technology in the world, so if you've got bog standard PSP or whatever it is, then it ain't going to do it. It needs to be good encryption. But it's something to factor into your assessment and your measures.
So it really goes back to this, what we're calling it, transfer impact assessment or whatever it is. Yes. What would you say are if you're going to go down this route, what are the key things, I mean, from amongst the team of what you should be looking at when it comes to this new form of risk assessment that we don't really know much about at the moment, but give it a stab.
Yeah, sure. So I think, as we mentioned, you'll need to consider which countries you are transferring your data to. You will need to consider what type of data you are transferring. Some types of personal data may be more sensitive in nature. You should also consider what sector you're in and what your processing activities are, because it may be that some organizations may be more susceptible to requests from government agencies. So more susceptible from requests under ISO 702 or the Executive Order 12333. I think those will be the main issues to cover under a transfer impact assessment. Anything else?
I agree. I think we could add, and I haven't got my head around this yet, but we could add that I also need to consider from where I'm transferring, because I think just saying from Europe might not do the trick. If I need to do a comparison to some extent, I might need to consider even the EU member state. I'm not sure whether and if so how, but at least that's something we need to think about, I think.
The hope is that we can also, in the coming weeks, look to any regulatory guidance that comes out of the national DPAs and how to navigate this particular assessment.
I was going to say, I think for me that's key. It's one of the great things about GDPR is harmonisation. So if we all went on our own different paths and did different things, you're going to have very inconsistent assessments made organisation to organisation, country to country. So having the EDPB very quickly say we're going to take a consistent approach, that the regulators are getting together, that there's not going to be an assessment now, but we'll very carefully look through the judgment and the layers and help, I think is a really powerful, important thing to make sure that we all know the rules of the road, how to do this and how to do this consistently.
Yeah, and I like the idea. I'm pretty sure it will not be that way, but I like the idea of the black and white lists for the DPIAs. Perhaps we get something similar somewhere down the road.
Yeah.
In a not too far future.
This sort of data to China, it's okay. This sort of data to the US, it's not okay, sort of thing. I can't imagine we're going to get. I mean, that'd be great, but
I agree. It's a fairy tale, most likely.
Yeah, one way of doing the assessment. I don't know if anyone else saw it today, but Max Schrems has been a busy man. He's issued some diligence questionnaires for EU businesses to send to their US service providers, or indeed EU service providers with US aspects. Are you subject to FSA? Are you FISA? Are you, this, that, and the other? And do you know that if you transfer data without appropriate safeguard, you can be fined 20 million euros? Please tick here to acknowledge the risk. We didn't quite go that far, but it was quite amusing. I don't think that questionnaire is going to be used very often in earnest, but we'll see.
But I mean, the general tone from the various DPAs has been carry on and don't panic, hasn't it? Really, I mean, have you seen any other movement other than carry on and don't panic? And what do people think that the Irish DPA is going to do specifically about Facebook now?
Yeah, that's the key thing, isn't it? What are they going to do? And again, Schrems, wrote to the DPC today asking for an answer within 7 days. Please let us know your plan for actually finally making the decision. It's taken you 7 years and five court hearings, 3 in Ireland and 2 in Europe. Please now make a decision. So that's key. They're supposed to be independent, but they make a lot of money out of Ireland, out of big tech in Dublin. So I wonder if politics comes into play. Probably not. Probably not. But will they actually enforce against the standard contractual clauses in this? That will be a nuclear option. That will be worse than the judgment if that were to happen. I'm not going to predict it. Anyone else want to predict it?
Anybody else? Yes.
Rather not, to be honest. But I think David, what you said is fairly true, except for the Berlin again. But I'm not going to reiterate what they said.
I mean, that slightly leads us on to it. There's quite a few questions coming here about. I was going to leave till last, but as we've got there, Brexit. And given we're rapidly heading towards to exit, and it looks like it's going to be the 31st of December unless something extraordinary happens. But let's face it, something extraordinary could happen. What will the ICO take a different tack, or how do we see that affecting what sort of regulatory action might be taken now, or do we see it affecting, or will we just carry on?
Danger of talking too much. I'm sorry, but I've got some views in this. But there's a number of.
You've got views, Renzo. Put them out there.
There's a number of different aspects. The judgment and the criticism of data transfers last week, permeates everything. It permeates adequacy decisions of every country that's been whitelisted. How can you find Israel adequate? I've no idea what Israel's surveillance laws are like and what judicial oversight there is, but were they really scrutinized to the same extent, and if they were put through that same lens, would they survive? So coming back to the UK and Brexit, UK, we know, want adequacy. we also know as soon as the UK is out of the EU, well, is out of the EU, but out of EU law, no longer subject to the treaties, its surveillance regime is fair game, in the same way as the US is, and the same way as German law and French law will not be fair game. So that's going to be interesting, whether or not they're going to be able to negotiate adequacy, and if they do negotiate adequacy, whether or not there's going to be a challenge to ultimately to that adequacy decision, any other adequacy decision. It could happen.
I think UK government bodies' requests for access to data under the Investigatory Powers Act differs quite a bit to US surveillance laws, in the sense that it's kind of subject to more checks and balances, let's say. But as you said, it's going to put UK laws, surveillance laws, under much greater scrutiny in the context of the adequacy decision. So it's certainly not helpful to Brexit and this transition.
But and what about in terms of what we might do? Because there are people out there now listening and thinking, how long is this going to last? What's going to happen, at the end of the transition period? What about say UK transfers to US after the transition period? I mean, are we going to take a different tack there? I mean, we don't know.
We might do. We might do. We're not subject then to discussions on the Charter of Fundamental Rights in Article 7 and Article 8. No longer applies. But we still got the European Court of European Convention of Human Rights, which got similar principles in there. So whether there's going to be, a difference, there might well be a departure. But if there is a departure, that's where, an adequacy decision for the UK becomes more difficult for the sorts of reasons that I said. You can't have the European Union permitting transfers to the UK, which then permits transfers willy-nilly, to an unsafe destination. But that's such a long way in the future, David. I think but by the time UK's diverged sufficiently from the EU, we're going to be years away. And I think realpolitik over here, despite Brexit, as we all know, I think a lot of people know and share the view, will be aping the level playing field. For the sake of business.
Somebody's sent in a question, moving on from that, about insurance. Many cyber liability insurers may currently cover breaches, excluding fines, flowing from data transfers relying on the Privacy Shield. Does the panel expect insurers to insert express exclusions into their policies for reliance on Privacy Shield?
Well, that's an esoteric question. If I might, so I've never heard of that.
Okay.
But clearly, if it ensures for consequence of relying on Privacy Shield, that's now redundant language. And there's a point that anyone that's touching Privacy Shield, which I didn't have time to mention in my slides earlier, you need to look at all the contracts that you've got. You might have made contractual promises in relation to Privacy Shield. If you're an insurer, you might have underwritten something related to Privacy Shield. So you need to look at contracts as another sort of consequence of that. But I've never seen a policy covering Privacy Shield issues.
Me neither, at least not directly. If at all, indirectly through only ensuring transfers or anything else like which have been in compliance with laws, obviously, and then through this indirect connection, you need to also change your reliance and not rely any further on Privacy Shield. But I haven't seen it specifically addressed in the policy either.
Somebody's referring to a comment you made earlier, Florian, saying that the context of this judgment, you said, but perhaps not as bluntly, namely that the ECJ went out of its way to be as damning as it could have been, by which I mean it could have been a lot more ambiguous if it had chosen to do so. Does that reflect what you were saying earlier?
I think it's more nicely put than I said, but yeah.
So it's essentially that they there could have been other options that they provided and a bit of a grace period and to have given us some time to react to this. I mean, I have to admit, I was quite surprised. I looked for it. I read the judgment. I thought there might be something in there, but I couldn't find anything there that said gave us any real guidance at all.
And to be fair to the ECJ, it's rarely doing it. I think I've only found 2 cases totally unrelated to IT and privacy where they did something similar. It's an option that's there, but they rarely use it. And I'm not aware of any aside from these 2 non-related decisions where they did something similar. And as I said, they really specifically addressed that effect, at least by saying we don't see a legal vacuum that requires anything to do. So they catered for this statement of mine, not only really of myself, but they catered for that statement that there will be the cry for a grace period, and they did that with this statement. There is no legal vacuum, which is, I think, a 3-liner in the entire judgment. But yeah.
Actually, one thing you mentioned, we mentioned earlier about BCRs. What role might they play in overcoming the vacuum, the no legal vacuum? What role might they play in this?
I think Katalina made the main point. It's not a short-term solution if you don't have them already, right? And I'm not entirely sure how open the authorities are currently to negotiating and approving BCRs, giving a lot of uncertainties, not only coming from Schrems 2. And it may also raise the question, what actually do I need to address in BCRs now to cater for Schrems 2? And are the current ones already doing that sufficiently, etc.? So there are many open questions around it. It's a long-term goal and a long-term effort to take. So I'm not sure whether there's a big run to BCRs now.
I don't think so. It's not certainly not short term. Long term is the right expression for it. It's not even medium term. They're impossible. I think it's been 3 or 4 or 5 approved since May 2018 by the EDPB. We've got a whole bunch just stuck in the process. And we're told that any exchange by one regulator will take a year before they reply to you because it just takes too long. So the whole thing needs reform. But in principle, any challenge to transfer mechanism on the basis that US spy agencies have access to European data, should prevent BCRs being used for transfers to the US. Or any country which might have insufficient essential equivalence. In principle, they're not a panacea, and in practice, they're just impossible.
One thing we haven't talked about yet, but rather than look at the problems with the existing, I know we've had Safe Harbor and that died, and we've had Privacy Shield and that died. But I wonder if there will be a third in some kind of shape or form, and what that will look like. So it might be, it's a shame in a way that was another mechanism. It's another bit in the toolbox that helped us to transfer data compliantly. Having something that does work would be really helpful, but I don't know what the discussions will be on both sides of the Atlantic to look at something like that. So it felt like that was something the Commission was looking at. Mentioned softly at the start, but it'd be interesting to see how that goes.
I mean, there's an absolute, a massive political imperative to do it. I mean, Privacy Shield wasn't that different to Safe Harbor, but the European Commission nonetheless felt emboldened enough to, as Schrems put it, put lipstick on a pig, if you remember that expression. Might we do it again with, the bottom point about the last slide, which is not on your screen now, but I've got it on my second screen, potential for EU-US adequacy 3.0, which then ends up in 5 years' time in front of the CJEU again in Schrems 3, the third movie in the trilogy, or Groundhog Day. We're there again, and by the time we're in Schrems 4, I'll have retired. But it's I mean, they must be feeling bruised, mustn't they? But there's such an incentive to try to fix it. But will they have the barefaced cheek to try again with a sticking plaster? We've got a fundamental clash between surveillance laws outside of the EU and our fundamental rights.
But I really hope that they do give it another try, in particular as long as the EU Commission still thinks that working on processor to processor model contracts is not a priority, I think was the statement, which is it's one of the most ridiculous. Yeah, I'm not going to go into it, but at least Privacy Shield was something that allowed us to also being used between processes de facto. So I hope that's something similar. They give it another step, but I agree, Renzo, there needs to be a fundamental change to it. Otherwise, it's just going to be a plaster for the next 5 years. Could also be a tactic, but I'm not saying that this is something that they will do.
And there are some statements came out this last couple of days, haven't they, saying that the Commission are talking to the Americans, and so is the EDBP. So they're talking about how to overcome this, but I assume it's just talk, and we don't know what is going to come out of this at the moment. But wouldn't another Privacy Shield 3 still, I mean, as you hinted at, it would always come up against that problem of the US states services surveillance, wouldn't it? I mean, how would they get around that? I don't know.
No, they'd have to fix some of the deficiencies that were, that they have to, do something. So, one of the criticisms was the ombudsperson's lack of independence, and so they might be able to do something on that. But giving EU citizens a right of redress in the US courts, which we're told do not exist, and I don't think any of us, forgive me, but are experts in US law, but that's what the court said. Although I did see that the US government's evidence was completely to the contrary of that. So who knows what the position is in reality? We can go by the CJEU, but if the court is right and there is no redress, and that's a fundamental criticism, then how do they fix that without changing US law, which is not beyond the realms of possibility. There might be some tinkering with US law.
One of the questions on the Q&A there is, fundamentally, what's the difference then of transfers under Privacy Shield if the issue was US national laws, as opposed to transfers under standard contractual clauses?
Which is why it's hard to reconcile the two sides of the judgment.
It is. It's a grey line, but I think arguably it's a contractual difference. Under the standard contractual clauses, importers have this obligation to suspend or prohibit transfers if there is no adequate protection. So that can apply to a part of your transfers as opposed to the transfer as a whole. But also, I think under standard contractual clauses, it allows the importer and exporter more flexibility in terms of the transfer, because you're able to do that case-by-case assessment. And I think that's what the CJEU was trying to get at, in very broad terms.
Agreed, Katalina. That's right. And they deliberately went, as I said earlier, at pains to leave that possibility. You could pick holes in that, and I'm sure the privacy advocates, will, because I think the court also did say, it's not simply whether or not the importer does comply with the obligation not to give the data to spy agencies unless it's under a non-massive, non-discriminatory democratic society type of regime. But if they might, you ought not to transfer, and that if they might is the killer on that sort of creative argument, Katalina. But that's all we've got, and so. Let's hope that the EDPB, say something as sensible as you just said, when they announce.
Soon.
One that hasn't been mentioned is a standard contractual clause also in the process of being revised. I think people might know, or if not, might be interested in knowing. That was in the pipeline anyway. The old SEC, or the current SECs are deficient. They force you to choose, are you a controller or are you a processor? They do not deal with processor controller transfers. They do not deal with processor sub-processor transfers. All these things can be fudged, one way or the other in creative ways. But there's going to be a new modular version, and the Commission said in the wake of the judgment that they're going to accelerate that. So that might come quite quickly. But whether it does anything to help bolster, an argument on essential equivalence with those clauses, we'll wait and see.
because it may well be that these updated standard contractual clauses have to consider the transfer impact assessment we've been discussing.
Yeah.
One of the other Q&As was whether if you're looking to switch from Privacy Shield to SECs and considering the additional safeguards that the decision mentions, whether you should include any additional clauses in there. And I mean, I'd be recommending my clients not to be too hasty. Not yet. Let's see what happens. Let's see what the regulators provide guidance on.
Agreed.
Yeah.
Same here.
Certainly, if you're on the server side, the processor side, then absolutely. You know, what do we tell our clients when we're acting for the control of exporting data? The more you can get, the better. It's not going to increase your risk by sticking a clause in, you know, whatever it might say. But yeah, nothing hasty. I agree. Don't panic.
Don't panic. I think as we're drawing towards the end of our hour, is that the message to leave us with? Don't panic, because it looks like the regulators aren't at the moment. Anyway, I would just like to thank all the contributors to today's discussion. That was excellent, and also to everybody sending in questions. There were a lot on similar themes, so forgive me if I paraphrased a few, but they're very useful and very helpful to help that discussion and find out what sort of problems you're thinking about. With that said, I'll just wrap up and mention the fact that this has been recorded. Will be available on the SCL website for members to watch again later. If you're not yet a member, you can go onto the SCL website and see. Give you reasons why you should join. But that will be. We'll send an email around later on this week. And of course, just to remind you that if you did find this useful and you want to help our student schemes, please do go and buy us a coffee at the link that was on the chat panel earlier, buymeacoffee.com/SCL. And with that, I'd like to thank you all and say goodbye, and let's hope we don't have to panic too much. Thank you.
Thanks, everybody.